welcome today to our webinar hosted by the Dentons Global Employment and Labor Group. Today, we'll provide an overview on recent developments in industrial labor relations that impact businesses and employers in Canada and the United States. This is the first in a series of webinars we are hosting on industrial labor relations around the world. Future webinars will look at other regions, so please keep a lookout for invitations to follow. My name is Andy Gruber, and I'll be today's host. I'm a partner in Indianapolis, Indiana, of the United States, and I co-chair the Employment and Labor Group in the United States. Next slide, please. Today, I'm joined by my colleagues, Ariana Bouchard, a partner out of Montreal, Canada, Adrian Elmsley, a partner out of Edmonton, Canada, and Mike Disotell, an attorney out of Pittsburgh, Pennsylvania, in the United States. We ask that you please use the question and answer or Q&A box at the bottom of your screen to submit any questions that you may have. We'll try our best to address them toward the end of the event if we have time. Next slide, please. To start today, I'd like a quick review of the agenda. Following this brief introduction, we'll have a review of the current climate at the relevant Canadian and U.S. labor authorities. We'll then move to the U.S. NLRB ruling in McLaren-Macomb regarding severance agreements, similar employment documents, and how it compares to the Canadian approach. A comparison of successor liability for represented employees will follow after that. And then we will finish with Canadian and US approaches to companies attempting to combine multiple bargaining units at a facility. And as I noted before, if we have time, we'll review questions and answers and attempt to provide any additional insight that is possible. Next slide, please. As I noted, to put the entire day, the entire hour into context, we want to talk about the current climate at the relevant Canadian and US labor authorities. Next slide, please. To start off, from a US perspective, in the United States, the National Labor Relations Act is a legislative enacted statute that controls labor relations across the United States. That act created the National Labor Relations Board, a 5-member quasi-judicial body that handles administrative proceedings and interprets standards under the act. The board has both investigative and enforcement activity. With attorneys across the United States, the board manages and attempts to direct how the act is interpreted. Board members are appointed by the president with Senate consent to 5-year terms, with one member's term expiring each year. The current composition of the board is with only 4 of them, 3 Democrats and 1 Republican, with the last Republican appointee's term expiring last December. Under the Biden administration, the board has been shifting towards a more pro-employee set of standards, either by overturning the previous administration's rulings in favor of more democratic level standards or establishing new pro-employee standards entirely. The NLRB General Counsel, Jennifer Abruzzo, has signaled a desire to continue this through various general counsel memos and briefings and cases before the board. Ms. Abruzzo's August 12, 2021 General Counsel memorandum was a politically charged memorandum that identified points that the current administration is looking to change through enforcement actions and rulings with the board. This gives all of us a clear understanding of where the board will be going with its enforcement actions and will allow us to better counsel our clients and how best to proceed under this new shifting board under the current administration. With the upcoming 2024 election, there are certain points that that most practitioners feel that the board will focus in on in an attempt to change the law or regulation to be more pro-employee in advance of a potential change of administration the following year. With that, I would like to turn it over to my colleagues with a quick review on the Canadian perspective. Next slide, please.
Thank you. So in Canada, there is a shared jurisdiction over labor and employment matter between the federal and the provincial governments. So the determination of whether a company's labor relation will be governed by provincial or federal legislation depends on the type of business in which the company is engaged. The federal government has jurisdiction over employment and labor law for specific works and undertaking within exclusive federal jurisdiction. It would include banks, telecommunication company, interprovincial and international transportation companies. I would say that it's about 10% of the companies that are under the federal jurisdiction. 90% of the companies are under provincial jurisdiction. So it would depend the body of law that would apply to those companies when it comes to labor and employment would be determined by that. There's also a labor relation board responsible for interpreting and applying the law of the jurisdiction and for mediating and adjudicating certain employment or labor relation dispute in each jurisdiction, so at the federal level and in each of the 10 provinces. The Canada Labor Relation Boards in general are much less political than in the United States, in the US, while the nomination are done by the government in place as well in each of the jurisdiction. Generally, they would follow nomination, they would follow recommendation that are made by committees that would group employers and employees, a representative of the communities. There has not been any significant change to labor relation legislation in Ontario, British Columbia, or Quebec within the last few years. Alberta is right now in the midst of a provincial election. So depending on the outcome of the election, there could be significant change to Alberta labor relation legislation, which would obviously impact on the decisions that the board there could render. At the federal level, there was several amendments that were made to the Canada Labor Code recently in the recent year, including in the most recent budget, the federal government indicated its intention to amend the code to ban the replacement workers. Right now, those are banned in Quebec and British Columbia only. And another major development that I would say that impacted the decision and the climate at the labor board is a decision from the Supreme Court of Canada in 2015, where the right to strike was recognized to be protected by the Constitution. So this impact all form of government intervention in the right of unionized employee to strike, including essential service designation, imposed mediation and arbitration, and back to work legislation. So obviously it has impact on the decision of the various labor boards in the country. Next slide, please.
At this point, I think Mike Disotell will be giving a review of the board's opinion in McLaren and Macomb. Mike?
Thanks, Andy. And good morning, everyone. Good afternoon, depending where you're at. As Andy mentioned, the McLaren-Macomb decision was a decision from the National Labor Relations Board from February of 2023 of this year. As a quick factual background, the case began following the onset of the COVID-19 pandemic. The employer furloughed 11 bargaining unit employees and presented each one with a severance agreement, waiver, and release, which included a confidentiality provision as well as a non-disparagement provision. All 11 employees signed the agreement and accepted the severance. The board, in reviewing that severance agreement, waiver, and release, overruled prior Trump-era precedent and held that provisions which limit Section 7 rights, such as the confidentiality provision and non-disparagement provisions included, have the possibility of chilling the exercise of Section 7 rights, and therefore cannot be allowed regardless of how voluntary that document is. In other words, the mere proffer of such provisions is unlawful unless narrowly tailored. Taking that ruling, the board then looked at the confidentiality provision and the non-disparagement provision individually and actually struck both of them down in that case. For the confidentiality provision, the board noted the provision was problematic because it broadly prohibited the employees from disclosing the terms of the agreement to any third person, which the board noted would include would prevent the employees from disclosing even the existence of an unlawful provision contained in the agreement or from discussing the terms of the severance agreement with the employee's former co-workers. Under the National Labor Relations Act, employees have the right to discuss the terms, wages, and conditions of their employment, and this would unduly interfere with that. Turning to the non-disparagement provision, the board found this was also problematic because it did not define disparagement in a way that has been cabined to the term to its well-defined, well-established NLRA definition, which is disloyal, reckless, and maliciously untrue. And that comes out of prior board precedent, that definition. It said the provision encompassed employee conduct regarding any labor issue, dispute, or term and condition of employment of the hospital. And for that reason, that provision was struck down as well. Next slide, please. As you can imagine, that's kind of the case in a nutshell. But coming out of it, a lot of employers had a lot of questions, and the case itself wasn't quite clear on how broadly it could apply or how narrowly it could apply. So about a month later from the McLaren-Macomb decision, General Counsel Abruzzo published GC Memo 23-05. And this is really kind of the General Counsel's guidance on clarifying some of the open questions from McLaren-Macomb. It's really worth a read. It answers about 15 FAQs that discusses things from, where the decision applies to non-unionized workforces, whether disclaimer language is enough to salvage any kind of severance agreements, and things like that too. Some of the key takeaways, some of the points we want to kind of raise for everyone on the call were, first off, the retroactive application. The memo clarifies that the GC will treat the McLaren-Macomb decision as having retroactive application. The memo notes that while an unlawful proffer of a severance agreement may be subject to the board's 6-month statute of limitation, merely maintaining a severance agreement with unlawful provisions or attempting to enforce such an agreement outside that 6-month window could effectively restart the clock. So there have been situations where employers have sent severance agreements to employees and had them signed and returned. And do this McLaren-Macomb decision now is really kind of worth a look from employers to see if they want to enforce those provisions or whether they would be effective. Another takeaway from the GC memo clarification is other employer communications. So the memo implies that the reasoning in McLaren-Macomb, even though it really only dealt with severance agreements, could apply to other communications and documents if they're not narrowly tailored as well. That memo actually cites as examples pre-employment letters and offer letters. We also think there could be a potential application to handbook policies and provisions as well too. So for employers, it's worth taking a look at some of those provisions. And especially if you have confidentiality or non-disparagement provisions, thinking if they wouldn't need to be narrowly tailored a little bit more or revised accordingly based on this decision. And another key takeaway is any kind of disclaimer language or a savings clause that a lot of agreements and a lot of policies have. The memo explains that disclaimer provisions would not necessarily cure overly broad provisions, although they could be helpful in resolving any kind of ambiguity. The memo then reiterates that the General Counsel suggests from other cases that contract terms include certain model language, saying that employers are expressly allowed to engage in specific categories of conduct. Now, the key here is that this has not been adopted by the board, but it is one that the GC is now arguing in various cases before the board. And so it might portend for a future development that we want to keep an eye on as well too. Next slide.
Thanks,
Mike, if I could just jump in real quick with if we could go back a slide, please.
Sure.
Thank you. Oh, that's forward. Back. One more back. Thank you. So, Mike, I think it's important to note, and something probably could have better described at the outset with respect to the jurisdiction that the board has over employees. The McLaren-Macomb decision did deal with bargaining unit employees, but is this McLaren-Macomb decision just limited to bargaining unit employees, those that as in unionized employees, or is it all non-supervisory employees?
Yeah, that's a great question.
Of that for everyone.
Yeah, that's a great question. And it would be the latter. So even the non-unionized workforce settings, non-supervisory employees could be, this case could be applied to them as well too. So even if you don't have any unions that you work with or any kind of unionized workforces, you still want to make sure you're aware of the decision and how it could be applied to those non-unionized settings as well too.
So anyone below a management level or supervisory level employee, when dealing with the severance agreement, clients should take a hard look at McLaren-Macomb for that determination. But any management level severance or offer letter or contract, the McLaren-Macomb decision would have no jurisdictional control. Did I get that right?
Generally, yeah. So I think the one caveat there is management, the case could apply to management if management is supporting workers in the terms and conditions of their employment. There's a very narrow exception to it, but generally the case wouldn't apply to management severance agreements and things like that. Yeah.
Thanks a lot. I
Yeah.
appreciate that. Let's move on to the Canadian perspective on the same concepts, and I believe we'll go from there.
Thanks, Andy. The landscape, obviously, in Canada with respect to severance is a little different from most of the United States. There's in all of Canada's common law jurisdictions, there's an implied obligation on employers to provide non-union employees with reasonable notice of termination. Currently, there are no specific restrictions for severance agreements for provincially regulated employers in Canada. So severance agreements are enforceable. They generally take the term or take the form of a general release with provisions that are very similar to what Michael just talked about earlier. I would note, though, that there is a trend developing within Canada to introduce legislation in some provinces that would restrict the ability of employers to include confidentiality provisions in these settlement agreements. Those tend to come out of cases dealing with terminations or claims that involve sexual harassment or harassment and those sorts of things. So that's something that's on the horizon that we need to keep an eye out for. The situation is a little bit different for federally regulated employees. So for federally regulated employers, non-managerial employees who've been employed for the employer for at least 12 months cannot be dismissed without cause. So it almost converts federally regulated employers to quasi-unionized employees. And so in those circumstances, a federally regulated employee who signs a release in favor of their former employer will not be barred from bringing complaints for unjust dismissal under the Canada Labor Code, so long as they bring that complaint within 90 days. So that is sort of an analogous situation where for federally regulated employees, which is a fairly narrow band in Canada, it's a similar kind of rule that they basically cannot sign away their rights to bring a claim under the Canada Labor Code. On the front end of the relationship, employers can limit an employee's termination entitlements by including an enforceable termination provision in the employee's employment contract, sort of like an employment prenuptial agreement, if you will. And the concept of without cause dismissal and or constructive dismissal does not apply to union employees. So union employees can only be dismissed for cause or for shortage of work pursuant to negotiated layoff provisions in the collective agreement. The one final note I'd say on that is if you were dealing with unionized employees and there is some form of severance agreement, the union representing those employees would also have to be a party to that agreement. And that typically helps work out those issues with respect to confidentiality and non-disparagement, because typically in Canada, the unions will not agree to those provisions. So it's difficult to settle those claims without that. And that's it for the common law provinces, and I'll hand it over to Ariane for the Quebec perspective.
Thank you. Next slide, please. So Quebec is a bit different than the other provinces in Canada because Quebec is a civil law jurisdiction, unlike the other provinces that are common law jurisdiction. So I would say that our main purpose of law in Quebec is not necessarily the case law. It's a civil code of the civil code as it is in France. So the civil code of Quebec specifically provides that an employer must give a reasonable notice to an employee or compensation in lieu thereof before terminating their employment, unless they have a just cause to do so. The reasonable notice is pretty much the equivalent of the common law notice, that this is something that shall be determined on a case-by-case basis based on relevant factors such as position of the employee, length of employment, how difficult it would be to find a similar position. In addition to that, the Act respecting labor standard of Quebec also provide that Quebec provincially regulated employee who are not senior manager and who have worked for the same employer for at least 2 years of service cannot be dismissed other than for a just cause. So this is a bit the equivalent of what Adrienne talked for a federally regulated employee. But in Quebec, it's 2 years of service that it takes. Another point, that is different, Quebec versus the other province, is that pursuant to the Civil Code of Quebec, employer cannot limit an employee's termination entitlement by including a termination provision in the employee employment contract. In this regard, the Civil Code of Quebec specifically provides that an employee may not renounce their right to obtain an indemnity for any injury that they suffer where insufficient notice is given or where the termination is abusive. However, it does not mean that we can never conclude like severance agreement with the employee. At the time of the termination, an employee may enter into a severance agreement in which he or she release the employer in respect of any dispute relating to their employment or the termination of the employment. And such agreement will generally not be voidable. If they try to file a complaint after having entered into such agreement, it would be to the employee to prove that like their consent was vitiated by error or fraud, something like that. Otherwise, the severance agreement will be valid and people will be barred from like suing the employer with respect to something for which they sign a release. When it comes to unionized employee whose employment is terminated, as long as it's terminated in accordance with the provision of the collective agreement that is applicable to them, they are only entitled to the remedy provided in the collective agreement, even if this is less generous than what they would have get like if they were entitled to a reasonable notice of termination. Obviously, the collective agreement restricts a lot the right of employers to terminate the employment other than for a just cause. It's limited to situation like business closure, for example. So because of that, employee would get like a lot more protection. That's all for me. Next slide, please.
Well, thank you both. A quick question for each of you, or either of you might be the better way to say it. Both Adrian and Ariana, you use the terms cause and just cause within the context of your discussion. And curious as to if you could provide some insight as to that standard or burden and whether those terms could be defined by contract as opposed to common law.
Thanks, Andy. I can answer that from the common law perspective. So cause or just cause are really interchangeable terms. And they would require a very high degree of employee misconduct. Sort of a degree of misconduct. The test that the court applies is that the employee has to engage in a degree of misconduct that's sufficient enough to permanently damage the employment relationship. So it's a very high standard to meet in Canada. Typically, you would need something like employee theft or an extreme neglect of duty. Sometimes it can apply in poor performance where there has been performance management over a series of warnings to the employee to the point where the employer can then conclude that that the threshold of just cause has been met. So that's the standard that gets applied there. And sorry, Andy, I've already forgotten the second half of your question there.
Well, the second half of my question was, could that common law definition be impacted by a contractual defined term of cause in an employment agreement or some of the like?
That's also a good question. The short answer would be probably not. In certain provinces like Ontario, they have a specific definition of when an employee can be terminated without providing any notice. And that definition, ironically, is narrower than just cause. Other provinces, what you can do is, so long as the definition of just cause that you adopt in the contract is consistent with the legislation in each province that sets the minimum standards for the employees, then you can use that definition to help sort of guide people as to what will be considered just cause. But typically, if you overreach on those sorts of definitions, the court will intervene and say that clause is not enforceable. And that can cause problems because if a portion of a termination clause is not enforceable, the entire clause is not enforceable. So typically the advice we give is don't try and define just cause, just rely on the common law definition.
Thank you. That's very insightful. Ariana, I won't let you off the hook without a question. I had a quick one. You spoke about union rights to certain remedies upon a plant closure termination event. Now, in the United States, if the collective bargaining agreement is silent, there is an obligation between the employer and the bargaining unit to bargain over those remedies. Is there a similar circumstance in place in Canada, or are most collective bargaining agreements fairly defined in a separation event severance?
I would say that most collective agreement would plan for that. And the other thing is that a collective agreement can never can never be less beneficial for employees than the employment or labor standards legislation. So, for example, if the collective agreement does not provide for anything in terms of like if for business closure, the employee would at least get the statutory minimum entitlement that they would get, because this is implicitly incorporated in all collective agreement, even if the collective agreement does not specifically mention it.
Thank you very much. I'll now speak on the US side of the comparison of successor liabilities for represented employees, and I welcome my co-panelists to pepper me with questions since I've put them on the spot as well. So if we could go to the next slide, please. We're talking generally about the Burns Doctrine, but if we take a step back, what this really involves is what are the obligations of an acquiring entity when purchasing through an asset purchase agreement, the bargaining unit, the bargaining obligations of the target. So in this instance, and where Burns, the Burns Doctrine comes into play, it involves what happens when whether that's a unionized acquiring entity or a non-unionized acquiring entity is looking at a target that has a bargaining unit inside of it. That may be an entirety of the workforce. It might be a section of the target's workforce. But in any of those events, the acquiring entity needs to take very careful steps to make certain that it retains flexibility in setting the terms and conditions of the employment of that bargaining unit following the acquisition. Now, when we look at this, we first determine what are the board successorship doctrine and what does it require? Well, the board has determined that any purchaser, acquiring entity in an asset transaction to recognize and bargain with the union representing a seller's employees under certain conditions. And I note that there are two important concepts there: to recognize the union and to bargain with the union. Each of these are key because an entity acquiring a bargaining unit is going to be obligated to recognize that bargaining unit. You cannot simply wipe out the recognition of the bargaining unit in place of a target through an asset transaction. Now, whether there is an obligation to bargain and what extent of that bargaining should take place is more where the Burns Doctrine begins to review. But when does that recognize and bargain obligation take place, and what conditions must be met? Well, there are two of them. First, the acquiring entity needs to continue the target's business in substantially unchanged form. And to go a little bit deeper in what that exactly means, the courts and the board have a 5-part factors that they look at to make that determination. First, is the workforce the same or substantially the same? Second, is there substantial continuity of the business operations? Third, is the work itself being performed at the same facility? And are the jobs performed under similar working conditions? Does the buyer or acquiring entity use the same supervisors, machinery, equipment, and production methods? And finally, does the buyer manufacture the same products or sell the same services? Now, each of these factors can stand alone to apply the substantially unchanged form element or in combination thereof. So the first situation that any acquiring entity needs to look at is essentially, are you going to be manufacturing the same products and services from the same facility, using the same employees in the same circumstances with predominantly the same set of supervisors and production methods. If all those are generally met, which they typically are in most asset purchase arrangements, but not all, then that first element that the acquiring entity is continuing the predecessor's business in substantially unchanged form is likely going to be checked. The second issue is a bit is much more important, and that is whether the the acquiring entity will be hiring hiring a majority of the target's employees as part of its post-closing workforce. In this event, you're looking at the bargaining unit employees and how many are you hiring. Now, you also need to understand that a directed effort by any acquiring entity to avoid purposefully hiring a majority of the predecessor's employees as part of its post-closing workforce just to avoid any successorship liability with respect to the recognition and bargaining with the union could be seen as a violation of the act. So it is something that every acquiring entity should look carefully at when it is considering what and how they're hiring. Now, if both of those situations are in place, then you have both a recognition and bargaining obligation with the union under the current collective bargaining agreement. However, an acquiring entity is not required to abide by the target's old collective bargaining arrangement if it makes, quote, perfectly clear to the union and the employees prior to or at the time of the offering of employment of the employees that it does not intend to be bound by the existing collective bargaining agreement. In that event, the acquiring entity can establish new initial terms and conditions of employment that differ from the existing CBA and then bargain with the union for a new agreement. So this is the circumstance that we strongly suggest clients to place themselves in the event that they are looking to acquire a unionized workforce. That is to say, at the time of offering employment, whether that is contemporaneous with the closing or just sometimes prior to the closing, communications should be had with the employees that the terms and conditions of the predecessor's CBA are not in effect and that new terms and conditions will be put in place. We typically suggest that conversations begin with the union and the target management labor relations boards at an early stage or close there to the closing so that it is perfectly clear to the union employees that new terms and conditions will be put in place. Now, if that is all put in place, as I mentioned at the outset, you have to still recognize the union, but at this point, you've been able, as an acquiring entity, to set new terms and conditions and then sit down at some point following closing or contemporaneous with closing to negotiate a new collective bargaining agreement with the union. That is our recommended best practice in these circumstances and provides acquiring entities the most flexibility in acquiring a unionized workforce. Now, of course, successorship liability can be complicated by local ordinances or public contract rules that require a successor to hire the workforce of a predecessor. You typically in the United States find those in what we commonly refer to as trades agreements, those large trades agreements that deal and manage in the construction industry with electricians and plumbers and other skilled workforces that require any entity operating in a geographic area or in a specific area of the country to abide by a collective bargaining agreement amongst the trades. Now, whether those laws are preempted by federal labor law with respect to local ordinances is an open issue, but in each circumstance, when you are looking at the potential acquisition of a collectively bargained workforce, it is strongly suggested that a pause is taken in place and a labor lawyer is put with the deal team to make certain that you get through the perfectly clear circumstances and that you manage any specific trades arrangement or local ordinances so that you are provided the most flexibility in moving forward with the best terms under the circumstances. Also, that would also greatly assist in the target's purchase price and overall any other kinds of post-closing determinations. I think we can go to next slide, please. For the Canadian perspective.
Thanks, Andy. So not unlike Canada and the US, there are some similarities, but also some big differences under Canadian law. So under the sale provisions of provincially and federally, provincial and federal labor relations legislation, a successor employer is bound to the terms of any existing collective agreement signed by its predecessor as though they were a party to the agreement. So the option of renegotiating terms after the closing of the contract or the transaction doesn't really exist in Canada, unless the board makes a determination that you're not bound by the collective agreement. And typically that would mean you're not a successor. So if you're a successor, you're going to be bound by the terms of the agreement that the vendor has. And that being bound by that agreement comes from it's by operation of law, and it's as of the date of the closing of the transaction. Whether you're actually going to be found to be a successor and bound by those provisions is whether or not a sale of a business has occurred. And generally what the board looks for in that is to see whether a viable economic vehicle has been transferred from the seller to the purchaser. And as you might expect, the board takes a very expansive view as to what constitutes a sale of a business. But this is, I think, where the similarities come in between Canada and the US. The kinds of factors that the board will look at to determine whether a business has actually been transferred by way of an asset sale deals with the consideration of a number of factors. Again, none of them are determinative by themselves, but it's usually a cumulative effect. But the things that they look at is the type of work covered by the terms of the collective agreement, the type of assets that have been transferred. And that would mean, have you transferred equipment? Have you transferred accounts receivable? Have you transferred contracts with suppliers or contracts with customers? Those are generally very important things to look at. They'll also look at whether goodwill has been transferred, whether employees are transferred, whether the business is operating under the same location, and whether there's a continuity of management and whether there's a continuity of the work performed. So again, they're trying to figure out, have you just bought a forklift or have you bought a business as a going concern? Like I said, no single factor is determinative. And in some industries, one factor will have greater weight than others. But typically going into these transactions, the default would generally be assume that you're going to be a successor, and the collective agreement is going to be an agreement you're bound by after the transaction. And that's it from the Canadian perspective.
Thanks, Adrian. Quick question, just from what you see in your practice, I believe Ariana mentioned a percentage of about just over 28% unionized workforce in Canada. In the US, an asset deal with a bargaining unit involved sometimes creates roadblocks or just we're going to step away from a deal. Do you see that in Canada at the same rate with such a high percentage of unionized workforce in Canada?
Yeah, I mean, that's an interesting factor. I think it really is specific on what province you're in, because even though we have a nationwide sort of 28% unionized rate, somewhere like Alberta, which I would sort of refer to as the Texas of Canada, our unionization rate is a lot lower. Also, I think the unionization rate, a large percentage of that is public employees, so municipalities, government employees, that sort of thing. But I do find that I've been involved in a number of transactions where once you find out there's a unionized entity, or in some circumstances, there's a union drive going on during the negotiation of the transaction, that will either make the parties hit the brakes, or they will be negotiating. The purchaser will basically look for much more favorable terms because they know the expense that goes in with being burdened by a collective agreement. So yeah, it is a big factor, and it's something that's that gets a lot of attention in these kinds of transactions to make sure that you're protected, you have the right reps and warranties with respect to unionization and what the terms of the collective agreements that the parties are bound to specifically are.
Thank you for that. I appreciate that. I think we can go to our next slide and our final topic for this hour, Canadian and U.S. approaches to companies attempting to combine multiple bargaining units at a single facility. I believe Mike is going to start off with the U.S. perspective. Mike?
Yeah, thanks, Andy. And next slide, please. So kind of what Andy had mentioned under the Burns Doctrine was you have Company A acquiring Company B, and then kind of merging the workforces from there. The accretion doctrine is what we call it in the US, where you have just Company A who has two different facilities. Maybe a facility, they could either be close to each other, or they could be further away. And they're looking to move employees into a new facility was already an existing bargaining unit itself. So the accretion doctrine is what's called in the US. The National Labor Relations Board does have a case on point that really does address the doctrine. It was the Safeway Stores case from 1981. In that, the board defined accretion as a valid accretion exists when the additional employees have little or no separate group identity, and those cannot be considered to be a separate appropriate unit, and the additional employees share an overwhelming community of interest with a pre-existing unit to which they are accreted. So there, the board was really kind of trying to get at where there's a community of interest between the employees. Are they doing similar work? Are they going to be performing it in similar metrics, similar policies, and things like that too? The board further discussed in the Safeway case that the purpose of the accretion doctrine is to preserve industrial, or as it's been defined by the courts, it is really meant to preserve industrial stability by allowing adjustments in bargaining units to conform to new industrial conditions without requiring an adversary election every time new jobs are created or there are other alterations in industrial routine are being made. So under the accretion doctrine, because the employees are being added to the existing unit without an election or other demonstration of majority support, the goal is really to promote industrial stability, but there is some tension there with employee Section 7 rights to freely choose a bargaining representative. And so the board really does take a close look at these to be sure that they're respecting not only the employees' abilities to show majority support for a union, but also make sure that they're creating the stability within the company that the management needs to have in order to keep their concerns going. So next slide, please. The NLRB analyzes different factors based on several criteria. No single factor is dispositive, and in fact, the different courts kind of construing the NLRB's position have also sometimes either added or subtracted different factors. I think the best maybe summary of what these factors might be is coming out of the Second Circuit. And they kind of look at 6 different factors, the way it's been summarized. They look at the standard factors concerning bargaining unit determinations. So things like geographic proximity, or are they close to each other? Are they far apart? Look at the similarity skills and functions of the employees, similarity of conditions of employment, centralization of the employer's administration. So that does the company have HR in different states depending on their operations, or do they have kind of a central HR that does national operations? They'll also look at managerial and supervisory control. So will the accredited employees be under the same management, or will they have a separate track? They look at the interchange between the employees. Are the employees going to be in the same office, same floors, interacting with each other? They'll also look at the functional integration of the employer as well as bargaining history. So have there been other unions involved? Have employees either accepted or either elected or rejected a union before? That'll also be relevant to that determination. Another criteria is the size of the group to be accreted relative to the size of the existing unit. And that's really more to make sure that the existing unit is not going to be overwhelmed by the new employees coming in to the point where it might change the culture or the perspectives of those bargaining unit employees. Another factor is whether the group to be accreted was in existence at the time the existing bargaining unit was recognized. That is relevant as part of the bargaining history. Another factor is whether the existing group is a result of prior accretions. So sometimes that does happen where you have an employer closing down different facilities and they kind of accrete employees along the way. So the board is willing to take a look at that perspective as well too. Another factor is the views of the employees themselves that are going to be accreted, whether they are for the accretion or against that. That is one of the factors that the board considers. And then finally, an independent determination whether the group of employees to be accreted constitutes an appropriate bargaining unit itself. In some cases, the board may realize you might want to have just 2 separate bargaining units at that facility rather than one bigger one covering that plant or that facility itself. And that is kind of the accretion doctrine in the US. I'll turn it over to our Canadian colleagues for this perspective.
If I could, of course,
Yeah.
you're not going to escape without a question, Mike. If I could, Mike,
Mhm.
knowing that this is a bit of a unique circumstance and in a rarely used situation, but noting also that you do have experience in this, could you speak a little bit to the audience about the advantages, disadvantages, and the purposes that you saw your client move through this accretion process?
Yeah. So just for a little bit of background, and you're totally right, Andy, this is a more of a unique, really used situation, but sometimes it does come up with clients. One of the times when we counseled on a matter like this was we had a employer who had operations in Michigan and operations in Ohio. They're looking to close the Ohio facility and accrete some of the employees up to Michigan, because even though you're going cross borders, you're close enough that some employees would be able to move in and take on those roles. And some of the things we did in our calculation there of whether we want to do the accretion or not was the different unions that were involved. They had a very good relationship with the union in Michigan. We're okay kind of continuing that relationship with a bigger unit. But then they also realized at the same time, like they had a relationship and a bargaining history with the union in Ohio as well too. So they didn't want to just kind of shut down that facility without bargaining over the effects of that and move the employees because they realized they could face a lot of liability in doing that as well too. So we kind of like walking through the calculus and make that determination. We looked at a lot of these factors and and we kind of were able to advise the client appropriately on that as well too.
Thank you. That's always very helpful. I think we can go to the Canadian perspective on this. Next slide.
Thanks, Andy. In Canada, it's sort of, again, similar principles, maybe a little bit less flexibility. So labor relations boards in each of the provinces and federally, they maintain a broad discretion to change bargaining unit boundaries and to determine which bargaining agent is most appropriate where intermingling occurs. At least in Alberta, we use the term intermingling rather than accretion, but really the same sort of principle where you're mixing bargaining units. The burden is on the applicant, which can be the union or the employer, to convince the board that the current units and the current boundaries are no longer appropriate. The appropriateness of a bargaining unit, there's similar considerations to certification, but they're a little bit looser. So they look at things like similarity in job functions, shared community of interest, the employer's preference for a single unit, the nature and degree of integration, and the length of the bargaining unit's existence. Union representation of employees in the appropriate consolidated bargaining unit will typically be decided by assessing the relative support of unions amongst the employees in the consolidated unit. And normally that is done by a representational vote. And typically that's where there's 2 unions competing. If, however, one union represents an overwhelming majority of employees in the consolidated unit, and in Alberta, different provinces use different thresholds. In Alberta, we use 80%. Other provinces will use a lower percentage than that. But if the threshold is high enough, the board will just go ahead and make the order without a representational vote. The same is true where the minority group is not unionized. Where we get into sort of sticky situations is when you have a merger of a non-union organization and a unionized organization. There is some indication that if the non-union organization vastly overwhelms the unionized one, then the bargaining rights will be lost. But as you can imagine, labor boards aren't super keen on that. And so there's always a possibility that you're going to end up having the board order a vote. So we have to be very, very careful when we're advising employers who are potentially looking at mixing unionized and non-unionized units or businesses to be careful, because you may end up getting a union that you don't want. So that's the perspective from the common law provinces, and I'll hand it over to Ariane for the Quebec perspective.
You're on mute, I think.
I'm sorry. This is quite similar that in the rest of Canada, when it comes to mingling and actualizing union bargaining unit. what must be said is that the Administrative Labor Tribunal has very broad power in matter of certification. It has the power to including decide whether a person should be include whether they are an employer or a manager, whether if there is a new position that is created, like either just like that or in the context of an acquisition, for example, whether it should be included in the certification. What must be said is that at any time after the certification, an interested party, it's usually either the employee or the union involved, or it can be the employer as well, may apply to the tribunal to determine the actual scope of the bargaining unit. In that case, the cardinal rule would be what was the international scope of the unit. So we must always come back to what was the intent of the party first, like regardless of like the words that are used. However, the search for intentional scope does not always exclude an evaluative interpretation of the bargaining unit, especially in situations like where there are a new group of employees coming in. So the scope of a negotiation unit is subject to natural growth, and in certain circumstances, the tribunal also has this jurisdiction to perform a true update of the certification. So, for example, update the terminology describing the scope of the bargaining unit, or even redefined by either merger or otherwise the bargaining units themselves.
Thank you so much, Ariana. And thank you, Ariana, Adrian, and Michael, the panelists today, for their insights and patience, even with my questions. I greatly appreciate that. And thank you for all who attended. We are at the conclusion of today's webinar. The panelists will follow up individually with the Q&As that may have come in during this process as we have reached our time today. But I wanted to thank everyone for attending. And if you have any questions, feel free to reach out to any of us or any of the Dentons lawyers across the globe and throughout the United States and Canada on any employment and labor needs. So with that, I'll put a conclusion, and thank you very much for attending. You have a wonderful day. Thank you.
Thanks to you, Andrew, as well.
Thank everybody.
Thank you.